Hello, hello, everybody. Sorry I'm late. Welcome in. We are going to talk about the Karen Reed case and do some recap and then get to the juicy stuff, which is the defense, Karen Reed's defense, third party culprit defense, and what that all entails because trial starts tomorrow morning. And it's one of the most anticipated trials for me personally. Probably since Casey Anthony trial. So that's a big one for me. And the reason why, for me personally, it's because of the blatant, in my opinion, blatant amount of disregard for policy and procedure in law enforcement, as well as corruption. You heard me right, corruption. Whether or not you believe or anyone believes that the corruption makes Karen Reed innocent or guilty doesn't matter. The fact that it exists, in my opinion, in this case is key. It's crucial because on this channel, I always tell people to get involved in their communities, know what's being done in their communities with authorities, because sometimes people just trust blindly. And as you know, the Lady Justice, right? Lady Liberty might be covered in her, her eyes are covered, but Lady Justice balances the scales with evidence, right? And if it's glaring, it needs to be addressed. And that's exactly what I feel is being done with Karen Reed's attorneys. It's very hard, in my opinion, to bring up a third party culprit defense unless it's pretty legit, right? All right, I'm going to say hi to everybody in the chat. And we're going to jump right in because there's a lot. There's a lot. Hey, hello, Mr. Eve. Good evening. Hope you all had a wonderful weekend. Thank you for being here and supporting me and this channel. Thank you. Yes, I appreciate you saying that. And I agree with Mr. Eve. Thank you for being here. Brooke, good to see you, love. As always, I get to see you soon. I'm so excited. That's going to creep up pretty soon. All right, we got Ryan. Good to see you. Welcome in. Justice Jane. A lot of people probably get their Karen Reed info from Twitter and or YouTube creators such as The Glare and LTL True Crime or LTL Podcast, something like that. And maybe Turtle Boy. There might be a lot of places that you go to. Chasing does an excellent job covering the Karen Reed case. Deets on the Streets. It's pretty much everywhere. A lot of people are talking about it. And Justice says Karen is guilty, in my opinion. She repeatedly told the paramedic she hit him. I have never seen the actual or heard of the actual audio where she says that. It'd be very interesting to see if that ever comes into play. Karen's version is, did I hit him? A question mark. Did I hit him as in a question, as could I have unknowingly? So that does not mean guilt at all. Matter of fact, the tail light, Brian Higgins, Brian Albert, Colin Albert, federal probe, all of these big ticket items that me personally debunks any, at least certainty that Karen is guilty. That's for sure. For me, that's just me. Everyone is free to believe what they want. Hey, Scout, good to see you. All right, let's just jump into it. So who's Karen Reed and what is this case? So Norfolk County, Massachusetts, Canton, Massachusetts, John O'Keefe, a Boston police officer who was dating Karen Reed for about 2 years at the time of his death, was found at 34 Fairview Road in Canton, Massachusetts, on the lawn of Brian Albert. Okay. Karen Reed finds him in the morning after being picked up by two of the party goers that night. Or at least one. I don't know. Was Carrie Roberts at the party? I'm pretty sure. We'll get into that. I got it all listed out. But at the end of the day, these people that were in the house at Brian Albert's house came from the bar that John and Karen were also attending. And John was extended the invitation to go back to Brian Albert's home. And the rest gets really muddy, as we know. There's going to be a lot of talk about witness testimony, or lack thereof, and some of state trooper misconduct and his role in being under federal investigation. You're going to hear stuff about proffers. So a lot of this live is going to be deeply invested into what the defense is saying versus what the prosecution is saying, because obviously the prosecution charged her and arrested her, and the probable cause and charging documents will list what they believe, whether or not it's been added or whatever. Motions to debunk certain things that they've said. So a lot of it, again, is going to be about the defense's third-party culprit, which is very rare in cases. It's very hard to convince a judge without just blatantly obvious circumstances and evidence and testimony. All right. Can everybody hear me okay? Put a 1 in the chat if you can. Hey, Jeep. I got Jeep invested in this. There's that corruption. Yep. Just tends to sneak up on us on these streets with these cases. Hey, Shani, good to see you. Good to see you. All right. Give me just a second. Let me pull up just a few things here. So again, Karen and John O'Keefe. I guess I should just pull up that. I'm so silly. I know pretty much everybody has seen a picture of John O'Keefe at this point. I would hope so. All right. But this is John O'Keefe, who was found on the lawn of 34 Fairview. And this is Karen Reed. Again, they've been dating for 2 years. They were kind of going through some issues in their relationship that has come to light. And one of the people who was at the party that was extended for John to come over and party with them, he is under a lot of scrutiny these days because of what the internal affairs investigation states, as well as the federal investigation, and some of the things that the lawyers for these certain individuals have said. We'll go over that. It's very important. It's not, to me, the judge in this case that has been here since day one. And the reason why I say that is because they were wanting to have her recused for her direct connections, or maybe not direct, family friendly ties. And I thought it was pretty obvious that it was there. But anyway, conflict of interest, basically. And she said, no, I ain't going nowhere. So she did not recuse herself from the case. I feel like she might regret that, maybe, potentially, perhaps, especially because of what she says in regards to certain people who are going to be under the gun with the defense. So, yeah. So, recap really fast. Pre-dawn hours of January 29th, 2022, a man was found dead in a blizzard outside a house in suburban Boston, which is Canton, Mass, in Norfolk County. He was wearing 2 shirts because it's very cold, blue jeans, socks, and 1 black Nike sneaker. That damn sneaker. And where's the belt? Anyway, they forgot the belt. Anyway, on the blanket of snow near his body were shards of glass and splotches of blood. His name was John O'Keefe, and he was a Boston police officer. O'Keefe and his girlfriend of 2 years, Karen Reed, had been on a bar crawl earlier that night. Shortly after midnight, according to court documents, they climbed into her black Lexus SUV and headed to an after party at the home of a fellow Boston police officer on Fairview Road in Canton, which is Brian Albert. About 6 hours later, O'Keefe's body was spotted in the front yard of the house covered in snow. But what happened during those 6 hours has sharply divided Canton, a town of only 24,000 people. And it's about 24 kilometers southwest of Boston. Residents of the town and neighboring suburbs have spent months debating two potential scenarios. Was O'Keefe beaten inside the house and tossed outside to die in the snow? Or did his girlfriend fatally strike him with her car? Local prosecutors have made their position clear, charging Reed with second-degree murder, vehicular manslaughter while intoxicated and leaving the scene of a collision. She has pleaded not guilty, and her trial is set for March, which obviously rarely a trial of this magnitude starts on time. It starts tomorrow. Right. So this was prior to all of the changes. This was like the end of 2023 in December. So that's honest to God the gist of it in the most basic way possible, with a few missing crucial details, which is witnesses, how many people were there, what they saw Karen do. Did they see John? Lucky Laugren, the snow plower, the snow plow driver, which all of these key witnesses did not in fact happen because of an amazingly swift and thorough investigation from police and state police. No. This is where Turtle Boy, Aiden Kearney, Doc, whatever you want to call him, comes into play, because he interviews and or brings up in his blogs, who, by the way, Turtle Boy, if you don't know who he is, shame on you, because everybody does. I mean, dudes everywhere. But he is involved because he is a journalist, if you will. And he reported on this case when no one else was really doing it. And this is why we are where we are today, in my opinion. A lot of it, he helped get the attention of folks in Canton and just Massachusetts in general, and the United States. Honestly, that's how I figured out that this case was there was more to it. Otherwise, if you didn't, you would just look at it and go, oh, okay, she probably did, drunk. Oh yeah, case closed. If she didn't have any resources or any backing that she has had, I don't think anyone else would be so lucky as to get the support. That's just my opinion. So this is Karen Reed. Obviously, this is Jen McCabe. Excuse me. And this is Carrie Roberts. Just keep that in mind when we're going through the basics, or continue to go through the basics. These two picked up Karen in the wee hours of the morning when she was calling around trying to figure out where John was, because she left John there. She left John at the party at 12. What was it? I think she left at 12:31. I have to check back on that time. I have my notes somewhere. But, she gets home, and around 12:41, I believe. And the only reason why I think we know that is because she was in the garage leaving John a scathing voicemail because she was upset. He never came back out to go back home or to invite her in. She was pissed. Pissed. I get it. And then they also see her leaving to go search for him herself at 5-something or 4-something in the morning, something like that. At the end of the day, when she gets back home and can't find him, she calls or gets in contact, and they come and pick her up And that's when they find John when they come back to the house and he's on the lawn. They acted like they didn't see nothing. That's just my opinion. They couldn't see him, but Karen Reed immediately saw him in the snow. And the audio that I'm going to play about the 911 call that was captured on John's phone, just by, I believe, circumstance and happenstance, John's phone was underneath him in the snow. All right. Not a lot of blood for the injuries that he sustained, in my opinion. And she was calling John's phone as she was, I guess, pulling up and saw him. So she left her phone in, I believe it was Carrie Roberts' vehicle or Jim McCabe's. Was it Carrie Roberts? I have to clear that up. But anyway, they were, just standing there. These two ladies right here did not move an inch, stayed in the car while Karen hightailed it to John and put herself over his body to keep him warm. But you could hear Karen frantically asking for help. And this one right here, the response that you'll hear is, I have gotten more excitement about going to the dentist than how they acted on the 911 call. That was recorded by John's phone in the voicemail. Blows my mind, if I'm honest. Let me check in my chat. Are we good right now? Any questions? I'm watching every day, says Jeep. Good, me too. I'm obsessed. I hope this trial goes as it should with all of the caveats that it's have and will have going forward. It's going to be wild. Hey, Eric. Good to see you, love. So this one right here, Jen McCabe, who was married to Matt McCabe. It's a party goer, the one that extended the invitation to John O'Keefe at the Waterfront Bar before Karen and John head over to Brian Albert's house. Okay. Julie Albert is married to Brian Albert, and they are sisters. Excuse me. So, I had a hiccup, sorry. And this is the one right here, if you haven't heard yet. It's the House Long to Die in Cold text message or Google search at 2:27 a.m. Yeah, she did. Art made it. Yeah. House Long to Die in Cold is this one right here. That's what she did. Now, why would somebody do that? You're going to hear a lot of hoorah and back and forth from Twitter, because I'm active as hell on Twitter with this case. That because the Cellubrite data exposes this, right? But the prosecution didn't use a certain type of testing to extract that data. It just skips right over that 2:27, because she does this again at 6 a.m., after 6 a.m., allegedly because Karen asked her to. Yeah. Who's buying that? Does anybody buy that? Not I. All right. So, who are the key players at this moment in time with the defense? There's a lot more to it, guys. You know that, and I know that. And that trial will bring it out if you're not aware. But most of the people know already. I mean, for the most part, they get the gist. And those little details, the defense, I promise you, if they can, will cover it. All depending on Judge Canoni. I thought it was Canon this whole time, but apparently Dietz corrected me yesterday that it was Canoni. Yeah, so I think that those little things, again, will certainly matter during and be covered way better than I could ever during trial, if the judge allows some of the things. I don't want to muddle it too much for people who just literally don't know all of the details. You get overwhelmed very quickly. Now, if anybody knows who Sleuthy Goosey is on Twitter or on social media, she deep dives into cases just like anybody else, but she does a very thorough job about putting timelines together and getting documents together, especially in the Delphi case. She did that for Karen Reed. She was also the one that introduced me to the Michael Vaughn case. She was the OG on that. You follow Sleuthy on X too, Brooke? That's good. Well, she definitely did an amazing job with this Google public Karen Reed spreadsheet for everybody to view all of the details, right? Who is who, trial testimony. She's got dates. She's amazing. She is the MVP of this case when it comes to organization. Thank you so much, Sleuthy Goosey. Oh, you love the intro? Great, great. Appreciate that. So you can actually access this yourself if you want to, I don't know, get a little nerdy and do it yourself. Or not. It's all gravy, but isn't this amazing? Look, she has it based on involvement, like who's who and how are they involved in the Karen Reed case or John O'Keefe. Amazing. There's a lot of folks. Excuse me, there's a lot of folks. And I think there's 70 plus witnesses, 70 to 75 witnesses, 35 from prosecution, and I think 35 from the defense, something like that. Wild, wild, wild. So Adam Lally is the prosecuting attorney. Alan Jackson and David Unetti are defending Karen Reed, as well as, what's her name? I always forget. Elizabeth Little? Is that her name? There it is. Elizabeth Little. I love her. Everybody thinks that she is like this weak, meek attorney that has a little meeky voice that, she's scared. Do not think for a moment that woman is scared of anything. She gets mad. And when she gets mad, her voice shakes a little bit. And I am like that too. So I get it. But I could tell she was pissed this last court hearing. Yeah, there are so many. It's ridiculous. All right. Now, another person that I would like to shout out is Chasing. She has actually done the audio breakdown for a lot of the Karen Reed documents, if you're interested, which is amazing. And I might even use one of them if she doesn't mind. Just going to wing it. I figured she wouldn't, but we might use one of them for the probable cause and all that good stuff. All right. Also, witnesses. So these are the witnesses. Nicole Albert, who is the aunt of Colin Albert, who was summoned by the federal grand jury on April 10th, 2023. We're going to get into that, along with Brian Higgins and Brian Albert. I've been looking all freaking day for the grand jury summons. It was on April 10th. So that's when the attorney for Brian Higgins got involved in regards to the Karen Reed case. Now, the federal proffer, I cannot wait to get to that. I learned so much today about federal proffers. I have never heard of that. Does anybody know what a federal proffer is? Put a 1 in the chat if you've ever heard of what a federal proffer is. It's one of my new favorite things. It's one of the, I don't know, most complicated yet unconstitutional, in my opinion, things for the defendant, in my opinion, because you're basically, I'll tell you what it is in a minute. I don't think anybody that I have ever worked with on cases at all, covering them, have heard of it either. One, only because you told me. Yeah, I did. And Mr. E can tell you I was like, mind blown. Mm-hmm. Jennifer McCabe apparently has MS. I did not know that. Apparently, she says. Wow. Sorry, I had a moment. So Brian Albert and Nicole Albert. No, I'm so sorry. Brian Albert and Brian Higgins allegedly are not targets of the federal investigation. Michael Proctor, who ran the investigation from start to where we are now, is under a federal investigation. And you will see exactly why here shortly. But the procedural errors, the misspellings in the case, ridiculous. Ridiculous. Like, come on. And to act like Michael Proctor is very, very close. I don't care what this is my opinion that they're very, very close, but the prosecution wants to make it seem like they are not close. The Alberts and the McCabes and the Proctor family are not close. They close. They close. They real close. And there's photos to really prove it. Matter of fact, didn't John O'Keefe's mother say like a second family to the McCabes? I mean, it's just wild how close they are to me, in my opinion. And it kind of just goes to add on to the validity of corruption, in my opinion. A proffer is a meeting between a criminal defendant or a suspect and the government that usually takes place at the local U.S. Attorney's office rather than in court. But there's more to it because there are multiple sessions when you voluntarily go to the feds and ask for a proffer. You have to voluntarily ask and submit for a proffer. And then you go through these sessions. It's amazing how it works. It's actually kind of a good way to protect each party involved, meaning the feds and the one that's wanting the proffer. Basically, you want to save your skin for knowledge of a crime that you are not directly going to be charged with, but you might if you didn't otherwise, right? So if you have information that you want to give on a criminal investigation, federal investigation, that's what you would do. Use a proffer for. Okay. So I'm going to jump ahead. Let's just say I have summarized it as much as you need at the moment, right? And I think I've done a pretty good job. If I miss something, let me know of crucial detail that the court or that the opening statement probably would cover anyway. But we're going to jump right into when the federal investigation documents were kind of coming out to light and some of the bombshells that were produced over time to where we are now. Okay. Let me get the court TV one open. 1 second. All right. Here we go. We are not going to use that audio. Actually, Law and Crime. What date was this? That was horrible. Oh, that's the most recent. I don't want the most recent anyway. Carrie Court hearing. I think it was August 2023. God, that was horrible. Sorry, guys. My bad, my bad. Of course, they're going to put in the latest and greatest. 1 sec. Sorry about
Your
that.
attendants may be seated.
Your Honor, this is 22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Adam Lally for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Your Honor, Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Attorney David Yannetti on behalf of Karen Reed.
Good morning, Mr. Yannetti.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right.
Could I just have, Mr. Reddington, could you identify yourself for the record?
Sure. Kevin Reddington, I represent Jennifer McCabe.
Good morning, Mr. Reddington. I appreciate you joining us today. I know that you're out of the country. Thank you. All right. So we have 4 sets of motions. The first one that
Damn it. I opened the wrong one again. My bad, y'all. One more second. I jumped ahead to January. One second. All right. My Discord does not direct, like the link that I pick, it doesn't do the same. It'll redirect to something else. Here we go.
Your Honor, if the court could define which of there's multiple motions, both from the side, the record holders from, or with related to Mr. Lally's motions, NBC, ABC, Alarm.com. Is that what the court's talking about, or the? Right.
and that he only heard back from one person. I know some of these motions were filed late, so my concern was that
God, doesn't that sound awful? Come on, Court TV. They be lacking. Law and Crime has been doing great, though. I'll pull that one up. Could anybody hear that at all? I couldn't.
Mr. Lally, am I reading this wrong?
No, Your Honor. Actually, number one that Mr. Jackson
All
is
right.
taking issue with is actually
That's
directly.
better. Okay, so this is in September of 2023. This is the court hearing that goes over a lot of important stuff, a lot of important motions.
I'm actually going to interrupt you. Mr. Lally, is there any objection from the Commonwealth?
So, as it pertains to the motion being allowed, no. The only objection, and that's why the.
Take a close look at the order. All right, so why 116, and now we'll go to the Google Nest motion, Rule 17 motion, paper number 125. Mr. Henning, why don't you come up, since this affects your client as the third party?
All right, so when they went to arrest Karen Reed for the upcharge of second-degree murder, what they did was go to a grand jury and present certain things and exclude a lot of things. And in my opinion, maybe misrepresent certain things. And the defense will come out later and kind of expose some lying on the stand, on a federal grand jury stand, that you'll see shortly. So not good, not good. But this Google Nest, I want everybody to have in mind when you're going to watch the trial, which again starts tomorrow. This Google Nest, in my opinion, depending on if it actually was activated or not, I don't know yet. But it's very important because it was I don't know if you know what Google Nest is, but it's like a Ring camera, but it's the Google version. Um, for the defense to want that information, I would assume that they think that it was on during the time of John O'Keefe's death, but somehow it didn't, or somehow Brian Albert just never installed this thing. So there's a reason why the defense wants it. So this is like camera footage among other camera footage that would be very exculpatory for Karen Reed. It just seems to magically either disappear or not exist until somebody brings it up, right? So just keep this in mind when you're watching the trial. Let's see what they say.
Okay. So why don't I hear first, I just like you up here, why don't I hear first from Mr. Jackson? Sorry if it makes it uncomfortable for you standing there. But why don't I hear, I guess you'll have to take a seat. Why don't you just sit down? Thank you. I'm sorry, Mr. Henning. All right, Mr. Jackson, I'll hear you on your motion.
Thank you, Your Honor. There's very little question that the security camera footage capturing the interior and exterior of the Albert home, the scene of John O'Keefe's death, is evidentiary, it's relevant, it's material to the defense, and it should be material to the prosecution, I would think. It should be material.
I have a proposed order from the Commonwealth, so I don't know that there is that much of an opposition to
There may
this.
not be, but there may be an opposition from, it sounds like Mr. Henning has some things to say as well, and so my comments are directed as much to that as it is to the Commonwealth. We've known for some time that there was a camera at the house of the Alberts, but what's truly interesting is how we know that there was a camera at the house of the Alberts.
Okay, so when Michael Proctor and Canton PD and all these people show up to investigate the death of John O'Keefe, you have to understand that detectives did not speak with the homeowners until after the fact. They did not go and investigate inside the home as a potential crime scene. They did not do a proper, in my opinion, and I'm pretty sure anybody's opinion with a brain, a proper investigation. They assumed, or maybe knew, that inside the home was off limits. Inside the home was not to be investigated, either purposefully or not. Either way, it didn't happen, and it should have. So, I mean, look, Brian Albert didn't even come outside when he was notified that John O'Keefe was there and had died. He didn't even step outside to nothing. It's ridiculous to me. But anyway, the Google Nest was not even mentioned in any way, shape, or form until grand jury.
On the date that John O'Keefe was killed. We know that there was a camera at the house, Your Honor, because a grand juror asked Brian Albert during the course of his testimony about the camera. It wasn't the Commonwealth that asked that question. The assistant district attorney went through 26 pages of questioning at the grand jury, a full panoply of questions surrounding the circumstances of John O'Keefe's death on January 29th, 2022, and not a single question was asked about security footage that did or did not exist at the time. A grand juror had to step in and ask that question. And that's interesting in and of itself, but this is a longtime law enforcement officer, Brian Albert.
I'm actually going to interrupt you. Mr. Lally, is there any objection from the Commonwealth?
So as it pertains to the motion.
Did you see how the judge just interrupted and asked the prosecution, Mr. Lally, if he had any objections? In my opinion, wouldn't you wait until, first of all, the defense is done speaking? Rude. But second of all, he didn't object. If he would have objected, he would have done so. Why do you need to basically coach your prosecutor, the prosecutor, for help? Come on now. And this happens time and time again throughout other hearings.
being allowed, no. The only objection, and that's why the Commonwealth filed a modified proposed order, because it's seeking records from Google.
Okay, so we'll talk about the proposed order. Before I hear you, because we have so much to do this morning, Mr. Jackson, I do want to hear whether Mr. Henning is objecting to this. Come to a microphone, please, on behalf of his client. It will save us some time if we direct it to the order if there's no objection.
I do understand. I don't think my comments are going to be very lengthy, but there are some things that I do want to put on the record on behalf of Ms. Reed.
Okay, I'm going to ask you to have a seat. I'll hear if there's an objection, and then you can figure out what you need to say if there's no objection.
So there was an obvious issue with this Google Nest information being kind of put out there for probably the public more so than anything.
Objection.
Good morning, Your Honor. Greg
Morning.
Henning on behalf of the homeowner. With the proposed order that the Commonwealth submitted in that language, Mr. Albert, the homeowner, has no objection to the rules.
Thank you. All right, I'll hear you now, Mr. Jackson. I don't know if you heard that. Did you hear Mr. Henning?
I think I heard him say that there was no objection.
To the proposed order from the Commonwealth.
The proposed order, the problem with the proposed order of the Commonwealth is it indicates that they believe that the information is appropriate prior to January 29th, which is in and of itself ridiculous. The whole point is to get the camera footage from the 29th, from the early morning hours of the 29th.
You can have it, but basically, Commonwealth is like, you can have it before January 29th, prior to John O'Keefe's murder. And Jackson here is saying, and that's not what we need. Duh. We need the January 29th footage. Ridiculous. So it sounds to me like there was obvious footage, installation of this camera, and has been used, potentially. But that's not what was said in the grand jury hearing. Let's see what they say about it.
We don't have, again, this has become a sort of a theme with the Commonwealth. They indicated they wanted to change the proposed order and literally put in the proposed order that any camera footage that we would get would stop at midnight on the 28th. We have to have the footage from the 29th. And I question whether or not that was as the Commonwealth...
Did you see number 3 of their proposed order?
The proposed order is...
I read it as it's asking for a longer period of time than you requested. It's more expansive than what you requested, Mr. Jackson.
Number 1 says activation or setup information for any Google Nest camera registered to Brian Albert or Nicole Albert prior to January 29th.
Right, that's 1. Number 3. The Commonwealth's proposed order is more expansive than the defendant's proposed order. If there's an objection to that, I'll hear you.
But obviously, there's no objection to us expanding the time. We want it as expansive as possible.
I just want to make sure you have the motion. Do you only have the first page of it?
No, I've got the motion. The motion was supplied to us, again, this is the second time this has happened, when I was on a flight yesterday.
Mr. Yannetti, did you receive this?
Yes, Your Honor.
So they obviously had a boofing of reading the entire document, but the prosecution to this day has a problem with getting things to the defense on a timely manner. To this day. So I could kind of understand this issue.
We both received it. I mean, I can read it on my phone as well as I can read it on a piece of paper. My issue is, as I indicated, I want to make sure that the proposed order extends to the early morning hours going through January 29th. As long as it does, then obviously we're on the same page, and I have no issue with the Commonwealth's proposed order. I want to make sure that, and I don't have any issue with the Commonwealth's proposed order as it relates to other Google apps, for lack of a better phrase. The activity apps, financial apps, things of that nature. That's not what we're interested in. We're interested in Google Nest data. So as long as that proposed order includes and encompasses January 29th, then we have no objection, obviously.
Mr. Lally, am I reading this wrong?
No, Your Honor. Actually, number 1 that Mr. Jackson was taking issue with is actually directly copied from his own proposed order. Number 3 is, as the court noted, a more expansive time frame that goes up until 8 p.m. because if there were to be video footage, the Commonwealth would be seeking that to expand beyond the police response and everything else that's been taken issue with over the course of this case.
Yes,
so
Shaney.
the only differences between the Commonwealth's proposed order and the defendant's proposed order is, number 1, excising any sort of other Google account information. Which
And I think
is
Mr. Jackson
relevant.
just said he didn't have an objection to that. All
That
right.
and expanding the time frame.
Okay.
The only wording that was changed under number 1 that we have an issue with is again, we believe it shouldn't be prior to, but inclusive of January 29th, any setup inclusive of January 29th, as well as the end of that same paragraph that indicates that the request is for information from any on-site activation by the residential user and not an activation that might occur at point of sale. There is no such thing as point of sale, to our knowledge, of a Google Nest activation system. In other words, the setup, I think that's a throwaway line, and I think it should be stricken from the order because it's confusing. There is no point of sale activation that we're aware of for Google Nest systems. But other than that, that's relatively pro forma. If sum and substance is that we get the Google Nest data, that's what we're.
So, okay, a lot of people got confused with this, and a lot of people kind of skirted by this Google Nest thing, which I looked into it and what they were saying, and then looked at the original motion, and what I feel in the most basic way that I can explain it is that they were trying to narrow, the Commonwealth, the prosecutor, was trying to narrow getting information from a basically a Google account from this Google Nest of maybe the purchaser of the Google Nest. But what I think is that they would need to know who was the owner of the activation of the Google Nest, which has all of the raw data. Does that make sense? And so they were trying to, in my opinion, sneak around the data. Maybe they wouldn't look into the accounts that owned that data and how to get it potentially. Because Google, you could subpoena them and you could ask them for data if they kept it, right? It just depends from the user. But I truly think that the prosecutor was trying to manipulate his way around the data, getting access to it, obviously, because he never even brought it up in the first place.
Concerned with.
All right. And you'd prefer that I add the expansive time frame than the less restricted time frame that you requested?
Yes.
All right, so Mr. Clerk, you can mark this. I'm going to hold on to it because I'm going to take a look at the orders more closely, but Rule 17 is allowed, no objection from the homeowner. So thank you for coming in for that, Mr. Henning. All right, so now we'll do the Commonwealth's the motion for the alarm. Is there an objection to that, Mr. Jackson or Ms. Giannetti or Ms. Little?
Nothing to touch on.
Okay. So, all right, I'll hear the Commonwealth. Do you want to start with, I have first the ABC News one. Why don't I hear you on that?
Just,
All right, so why don't I hear you? It doesn't matter to me whether it's ABC or NBC that you want to start with. All right, so do you want the opportunity to speak to legal counsel and see why they weren't represented here today, Mr. Jackson?
I would like that opportunity. It is unusual, I think. I suspect that there may have been, and I don't want to speak for the Commonwealth, they know better than we do, both NBC and ABC are out of state. I don't know that they...
If they want to be heard...
I will address those today, Your Honor.
And so when this motion was first filed...
Sorry, so that, what I skipped over was the NBC-ABC interview that they did with Karen Reed. The Commonwealth wanted, they put in a motion to get the full extended version of that interview with all of the things said to see if maybe they could catch her in something. Maybe she said something off the camera or during the camera, rolling the footage of her interview that they cropped out, right? Maybe she slipped up somewhere and she was like, oh, don't put that in there. That's not what I meant. Or something along those lines, right? I don't know if they got that or not. I'm not really sure. I don't think so.
And so when this motion was first filed, and I do appreciate, Ms. Little, that you did get it to me in a timely manner after the last hearing. I do appreciate that. And I appreciate the detail of it. So then we have the Commonwealth's response that then maybe limits some of what you have there. And then I've got your response to the Commonwealth's opposition. So I think that's where we have you focused. But has that changed at all since you filed this? I received additional statements of compliance by the Commonwealth.
I will address those today, Your Honor. There's 5 sort of outstanding categories of evidence that we still have not received. I did receive a packet of information today, but I'll go through that for the court.
Okay, go ahead. So let's do what you address in your reply.
Thank you, Your Honor. It has now been a year and a half since Ms. Reed was arraigned in Norfolk Superior Court. A year and a half, and the defense still has not been allowed to so much as look at the physical evidence that the Commonwealth has had in its possession for 21 months.
21 months, y'all. Think about that. 21 months of not being able to access key evidence that the Commonwealth is holding, in my opinion, hostage, but that's just me. And Lally's going to lie, and he's going to say, oh, I have X, Y, and Z reasons for it. But Miss Elizabeth nails his ass. And it's quite entertaining.
And has so desperately withheld from the defense out of fear of what it might show. That is unacceptable, that is unconstitutional, and that clearly violates the mandatory discovery provisions set forth in Rule 14. As I informed the court, there are 5 categories of mandatory discovery that continue to be withheld by the Commonwealth, and I'd like to go through those in turn. There are first 56 items of physical evidence that we have been unable to view, unable to independently test.
Are these the items that are at the lab for testing still?
That's correct, Your Honor. It includes all of the taillight pieces, all of Mr. O'Keefe's clothing, and all samples taken from Mr. O'Keefe's clothing and person. This is the seminal evidence in this case. Your Honor, this is not a complex legal issue. The United States Constitution, the Massachusetts Declaration of Rights, and Rule 14 all require that Ms. Reed be permitted to inspect and independently test this evidence. Rule 14 could not be more clear. Quote, the prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects at or prior to the pretrial conference. Our first pretrial conference was on August 12th, 2022.
By the way, this is Karen Reed's brother and Karen Reed's mother. And beside her, you can't see him right now, but it's her dad.
The compliance date for mandatory defense access to this physical evidence was more than a year ago. In opposing this motion, as Your Honor noted, the Commonwealth has tried to excuse its blatant discovery violations by claiming lab protocols and procedures simply won't allow us to access this evidence. But lab protocols and procedures are of no legal moment, Your Honor. They don't trump the law. In fact, Rule 14 actually contemplated that this might be an excuse that the Commonwealth gave. It specifically says it doesn't matter if the physical evidence is not in the physical, actual, tangible possession of the Commonwealth. If that evidence is in the possession of any agency who participated in investigating and evaluating the case and reports to the prosecutor, which clearly the Massachusetts State Police Lab does, then discovery is mandatory. That's Rule 14. As this court well knows, this is not the first time we've requested access to the physical evidence in this case. So when Mr. Lally stands up, as I believe he probably will, and says, we're almost done testing, the defense can have access to this in 30 days, I want to remind this court that we've been here before. In fact, we argued this exact same issue before the court 6 months ago.
6 months ago, they were having issues getting the evidence so that they could prepare for trial. It takes a long time. These big, high-profile cases take a long time. And we all know, we've all seen court hearings and the delays that it, look at Brian Kohberger's case. Good God. I think everybody was kind of afraid of, what's her name? Not Chad Daybell, but Lori Daybell. Lori Vallow. That her trial was going to be basically dismissed at that time because of the bullshit and the delays and wanting to go out of county and all that stuff. So we all know that happens. These little things happen, delays happen. But this is ridiculous. I mean, and she's going to nail him.
And I think it's important for the court to be reminded of the representations that were made by Mr. Lally at that hearing. On February 8th of this year, Mr. Lally stood here in open court and made these promises. Quote, I did speak with the lab earlier this week, as well as last week, a couple of weeks ago, and on several different occasions. But my expectation, from what I'm told, is that their analysis and report should be complete within the next 30 to 60 days. Those were Mr. Lally's words in February. And my guess is that's what he's going to say today. But what is disturbing about those representations is that the crime lab actually keeps track of their communications with Mr. Lally. And when you review the crime lab conversation log, which was produced to us in Discovery about a month ago.
Oh, they requested the conversation log, which is their right to have. And it kind of shows the timeline of who responded to who and when. Ooh.
This is what you see. Quote, note to file, date January 3rd, 2023. Entry by John Buello. Person contacted, ADA Lally. Note, quote, emailed Commonwealth prosecutor on 11/21/2022 about the status of testing. No response back. Therefore, the trace items will not be tested at this time. If for any reason testing is needed, the items can be resubmitted to the lab for potential analysis. Trace assignment closed, no report. And what you also see is that between January 3rd, 2023, which is the date of that entry, and the date the Massachusetts State Police Lab apparently closed this case, and February 8th, which is the date that Mr. Lally stood here in court and made those representations that he was so desperately trying to expedite testing, there is not a single record of communication between Mr. Lally and the lab that's contained in that conversation log. That's not Mr. Lally's hands being tied by lab protocols and lab procedures. In fact, the assignment was closed because he failed to answer his emails. That is deception, Your Honor. So when the Commonwealth stands up and says that the defense can have access to the physical evidence in 30 or 60 days, that's not good enough. We need court intervention. We need this court.
And it should have been a stern timeline deadline, in my opinion, 6 months ago at this point in time. Because again, this is September of 2023. And in December of 2022, the shit show that was going on with lack of procedure with the prosecutor with evidence. I mean, at some point you have to go, is this intentional, right? That's why the judge is there to say, hey, deadline is this for evidence to be handed over in its entirety to the defense, or it doesn't get entered, right?
To order the Commonwealth immediately provide us access to these critical items of evidence and set a date for compliance, because that's what the law requires. That brings me to the second category of evidence that we're missing. Your Honor, for quite some time, we've been asking for access to the Lexis infotainment system and the Lexis telematics system.
So the informatics system on Lexis, you know, the data that shows what happened basically during that time. From my understanding, they still don't have it. I could be wrong, but from my understanding, I still don't think they have it. I'll have to check on that, but that's ridiculous. It's really not that complicated. I mean, it is complicated, of course, but what I'm saying is it doesn't take 2 years worth of waiting.
As of this morning, our expert was able to get in touch with Trooper Garino, and they're currently working on coordinating a time to hopefully analyze that evidence. I'm hopeful that the Commonwealth will be forthcoming and allow us to obtain our own analysis. If there are any issues, we will plan to file a proposed protocol for the examination of that evidence with the court, but I'm hopeful it won't come to that. The third category of evidence is the handwritten notes of law enforcement. As this court is aware, it was filed with our papers. Law enforcement was ordered to preserve all handwritten notes taken in connection with this case. That was done in Staten District Court on February 2nd, 2022. And I know Your Honor sort of reaffirmed that order just in passing during one of the court appearances when we asked for her to renew it. We know law enforcement took copious notes in this case because most, if not all, of the reports were drafted weeks, even months after the actual interviews or investigation took place. We're asking for the court to immediately set a compliance date for production of those notes. If the Commonwealth has nothing to produce, then we also need confirmation of that because it's in violation of a court order.
Retro.
The fourth category are reports, handwritten notes, and mapping documenting the recovery of evidence from the Albert residence. This information.
this is super crucial that is going to be brought up. Like, this is like a compounded issue over time of violations of procedure, right? From law enforcement. And again, at some point you have to go, is this intentional?
Should have been produced over a year ago. If you were to review all of the police reports in this case, as we've done, then you might mistakenly believe that there were only 2 searches of the lawn of 34 Fairview Road that resulted in the recovery of taillight pieces. Those searches were on January 29th at 5:45 p.m. by the CERT team, and there was a second search on February 3rd, 2022. But those reports are not complete because according to photographs of the evidence bags in this case, which we just received on July 25th, Trooper Proctor claims to have actually recovered taillight pieces over the course of 5 additional undocumented searches of the Albert residence.
5 additional undocumented searches. So again, is this intentional? Do we understand just by that alone why Trooper Proctor, Michael Proctor, is under a federal investigation? It kind of makes sense just with that. Although the feds wouldn't just come in for, 5 undocumented searches. They need a little bit more than that. But I get it. That alone to me is important. However, if you think about it, for the prosecutor to not have this information available to the defense at this stage in the game, and they are incomplete, these reports are incomplete, you have to see the timeline of the details of this evidence and this undocumented evidence. That's where the corruption starts to creep out later on down the road when the federal investigation grand jury minutes come out.
Residents throughout the month of February. The only reason we even know about these searches is because when Trooper Proctor logged these pieces into evidence, he had to write his name, the date, and the place those pieces of taillight were supposedly found, 34 Fairview. That's 5 undocumented searches, Your Honor. We don't have a police report for any of those. No notes, no reports, no photographs of where those taillight pieces were found in the yard. No memorialization of the individuals who called Trooper Proctor to the scene. That is not acceptable. If this information exists, we're entitled to it. We need a short compliance date for the production of these notes and reports so that we can at least attempt to prevent further fabrication of evidence. The 5th category of evidence, Your Honor, is the raw data associated with the CERT team's search on January 29th at 5:45 p.m. We received a disc this morning from Mr. Lally. I obviously have not had a chance to review that yet, so I don't know what's actually contained on it. This has become somewhat of a pattern in this case. So I'm hopeful that everything's on there, but I'm not able to guarantee that for the court. He also indicated that there are additional materials that are forthcoming. Obviously, we haven't received those yet. I'm asking the court to set a compliance date to make sure that we actually get the information that we've requested.
Okay, thank you. Mr. Lally?
Your Honor, I'm not quite done.
Oh, you said there were 5.
I was going to have a conclusion if I
Okay.
finish addressing the court. Thank
Sure.
you. Your Honor, we are entitled to this discovery and we need compliance deadlines. Ms. Reed has a constitutional right to a speedy trial and to prepare and present her defense. The law is clear that Ms. Reed was supposed to have access to all of the requested information in August of last year. Respectfully, Your Honor, we're asking you to please enforce these rules and get Ms. Reed the discovery that she's entitled to. Thank you.
Thank you. Come on.
Yes, Your Honor. Most of what I believe was just addressed was dealt with in the Commonwealth's response.
Sure, he's speaking in a microphone right in front of him.
As far as whatever the
So I'm going to summarize it for you. You can watch it for yourself if you need to save time. He dances around this issue as if it's a timing problem or whatever it may be. He does not address why 5 searches were undocumented with these 5 entries of evidence of taillight. Never really addresses that. But it does come out eventually, right?
Mr. Lally, earlier when you talked about the DNA, you said, okay, Ms. Little, any follow-up with that?
Yes, Your Honor. Mr. Lally just listed a lot of lab work that has been done in terms of DNA testing. I just want to clarify for the court. I did review his opposition. There are only 2 items that are still subject to comparative testing. So we're asking that the rest of the items of evidence be made available to us immediately. There's no reason to continue to withhold those from the defense. As to the Lexus infotainment system and the telematics system and the EDR, as Your Honor can imagine, it's quite expensive to fly an expert from out of state to go look and interpret this data. We're trying to avoid having to do multiple trips of that. So while I understand the airbag control module and the EDR, which we already do have the data from them, are generally available, we're not.
So, okay.
We're going to skip
There is an
that.
objection.
Okay, so let me hear the Commonwealth end of the
Fine.
motion, then I'll hear your
That's fine.
objections. My question was simply on the impounding of the attachments. There's an objection to the impounding of the attachments?
No.
Okay, that was that question. I'll let you be heard on the motion, Mr. Jackson, but I'll hear from the Commonwealth first. Mr. Clerk, the results that are attached here. Commonwealth satisfied me that they
I
qualify.
believe
for
this is
impoundment,
grand
and I
jury.
impound them.
This is important.
Yes, I'll put that in here. All right. Mr. Lally, I'll hear you on the exhaustive testing motion.
Yes, Your Honor. So very simply put, there is 2 items that, as I just referenced earlier, had been subject to DNA testing in July of this year. Among those items was the root end of a hair, item 3-6.1 from.
Oh, I'm sorry. This is the hair. Okay. This is important too. They held Karen Reed's bond at, I believe, 80,000 instead of 100,000, but it was 80,000, I believe, based on the hair being into the probable cause and her being a flight risk and all of these things. It turned out that the hair, or I'm sorry, the bail reduction motion, I apologize. They didn't want to reduce her bail, or bond rather, because of all of these things, including a figment of our imagination, this hair of John's that turned out to not be hair.
Item 3-6, which was a hair that was recovered from the rear bumper of the defendant's vehicle. The testing that the Commonwealth is requesting would surely be exhaustive based on the size of the sample. The MSPCL, the State Police Lab, does not have the ability to conduct mitochondrial DNA testing or the testing that the Commonwealth is requesting be done in this case. We've identified an external vendor. This item was initially marked by the State Police Lab for an external vendor because of that reason, because of
as it pertains to the hair, the history of that hair is somewhat tortured. The Commonwealth has been trading on the argument in front of this court and in arguments, both oral arguments and motions that they've propounded or filed, that this item that was found on the back bumper on 3-6, which is 3-6.1, is in fact a human hair. They've gone so far as to suggest the relevance of that item is it's not just a human hair, it's John O'Keefe's hair, which would establish some sort of physical evidence that my client is, it inculpates my client.
Basically, this is the smoking gun, and you'll see it on Twitter with all of the trolls and the McAlberts and all of them. What about the hair of John O'Keefe? It's on the bumper. Oh, is it?
Except when we demanded that the hair be tested under the watchful eye of one of our own experts, which we had not had the advantage of doing at any time prior. It turns out that it wasn't a human hair. On August 25th, 2023, there was DNA testing done on 3-6.1, and the analysis resulted in, quote, no human DNA detected. STR analysis not performed. I'm holding the DNA results. So after a year and a half, so 19 months or so, of saying this was a human hair on the back of that bumper, turns out it's not a hair. And DNA testing indicated it was not a hair. And now the Commonwealth seems to be in some sort of triage mode to try to figure out how they made a mistake. And the mistake is, actually, I question whether or not it was a mistake, because you can make a mistake once. I don't know that you can do it 4 separate times. In 4 different filings before this court, 4 separate times after August 25th, after they had this document in their hand, which the highlighted portion says, no human DNA detected. they filed motions with the following phraseology. Quote, the hair has been forensically confirmed to be a human hair, end quote. Not once, not twice, 4 separate times, and the last time was just this past week when they filed something in front of the Court of Appeal with that exact same phrase.
So how in God's green earth, in my opinion, only, could you, as a judge, sit there and see the debacle and the fuckery of that hair, which was used against her in her bail reduction motion that the defense entered for her? And it turns out to not even be hair. And they are sitting there claiming it is human hair and John's hair? I have never. Boy, if I were a judge and I was seeing that, I would really do a competency hearing. Do we need to talk to Norfolk County Prosecutor Attorney's Office and let's reevaluate where we're at, because you blatantly lied to me. You blatantly lied to the Commonwealth. Why? And so that's why I feel like Canoni helps out her fellow court officer, Lally, Prosecutor Lally, because he's terrible at this. He's really terrible at this. So is there some invested interest in the prosecution going to trial? That's always been my thought. What is the benefit? Knowing that there's so many issues from start to where we are now, from the Commonwealth and from law enforcement, anyone that says Karen Reed is guilty, basically, from the legal and judicial standpoint, why would they need to go to trial? In my opinion, there was no other option for everyone involved, no matter what. There was no other way to go about it because of the circumstances of people being exposed for all of the different things, whether it be full-blown corruption or failing to do their job properly or knowing each other too damn well, conflict of interest problems. And I would give Turtle Boy all of the credit on this, exposing those people who were obviously in some way knowledgeable or involved in some way in exposing themselves without knowing it by being assholes around the witnesses that were potentially involved in this cover up, potentially, allegedly. You got to give Turtle Boy credit for that because he did that. He was the one that had the balls to go out and say, this is what happened. And he literally spent time in jail for it, in my opinion. And it's not, he knew that. He even foreseen it later, and it happened because of the witness intimidation and all that bullshit that was charged on him. So he got a special prosecutor to nail him. It's stupid. It just goes to show there is an abuse of power in Massachusetts.
The hair has been forensically confirmed to be a human hair. Your Honor, at some point, that's not a mistake. That's a deception. That's a knowing fabrication. That's a lie. And I don't use that word lightly. I'd love to consider this conduct feckless and irresponsible, but it's not. To do this 4 times, this is pernicious, and it's intentional. So when the Commonwealth comes to us at the 11th hour and says, oh my goodness, hang on a second, let's all take a time out. We want to destroy the very item that we've been trading on falsely for 18 months to do mitochondrial DNA testing, which, as Mr. Lally indicates, he's smart enough to know, the lab is smart enough to know that's completely destructive testing. That will be exhausted, it's gone after the mitochondrial DNA is done. I expect that Mr. Lally will say something along the lines of, well, we were just trading on the idea that Maureen Hartnett at our crime lab microscopically confirmed that it was a human hair. And she did. What's the problem with that? She failed her proficiency exam the month before she did the examination. On the exact same issue, and it's not like a generalized proficiency exam, it's a proficiency exam dedicated or focused on whether or not she can microscopically determine a human hair. and she failed that. So they have Maureen Hartnett saying it's a human hair. She's not even qualified to say it. Then they go back and DNA test it. It comes back not to be a human hair. Then they say we want to destroy it.
I mean, I don't think it could have ever been explained more thoroughly and clearly than that. I mean, she failed a proficiency exam on the very issue that they are discussing with the hair. Bruh. This is why this case, like, it hooks you with the things that this doesn't just stop here. It gets more insane as you go. This is in September of 2023. I skipped a whole bunch of stuff. That honestly, it will come out in trial. All of this will. But those are the key things that I feel are going to be groundbreaking in this case is the Google Nest information, other missing footage, pieces of footage like the library footage that they obtained where they have detectives saying that they saw with their own peepers the footage of Karen Reed driving here and there, okay, which gives the timeline basis of where she was at what time. But it would have also shown her tail light, which is like the biggest problem in this case, is that her tail light was not cracked and shattered like the Commonwealth is stating it was, that allegedly hit John before leaving at 21? Or 12:31, something like that. I mean, come on. There's so many exculpatory pieces of evidence that would pretty much, in my opinion, exonerate this woman, and that it just vanishes. It just keeps vanishing and vanishing, or not being able to be produced. And no wonder there is an internal affairs investigation from the Massachusetts State Police. And, of course, the federal probe, who is targeting Michael Proctor officially. That's official. That is a fact check. So we're going to jump into where we are now before trial. Okay, here in just a second. I just wanted you guys to remember that. I think it's important personally in this trial, the Google Nest and the missing footage. That's just me.
Notes, photographs, everything pertaining to that has already been provided to counsel. All of the testing results have been provided to counsel, and we're asking for it to be, for the court to order or allow or permit it to be sent to this external vendor to conduct this testing and bring in the order before the court because of their observation policy and because the likelihood of the...
Nothing to do with any destructive testing whatsoever. It's going to be reviewed microscopically by...
When I consider this motion.
Thank you, Your Honor.
All right, so we'll move on to Mr. Yannetti's motion as to why I should change the conditions of release.
Thank you, Your Honor.
May it please the court, I appreciate the opportunity to be heard. Your Honor, I stand before you because it is in the interest of justice for this court to lower my client's bail to personal recognizance in exchange for Ms. Reed turning in her passport and signing a waiver of rendition. We make this request because there are numerous important changed circumstances that have come to light since bail was last considered and modified. I would argue that we have a little bit of a different situation here. Generally speaking, somebody qualifies as indigent because they can't afford an attorney, they can't afford any experts at all. That's not what we're saying. What we're saying is there's an overwhelming financial crush with regard to learned that was a lie. It leaves us, Your Honor, with the bail. They can't afford any now serving no purpose other than to prohibit my client from using that money to properly defend herself. Your Honor, every time this bail has been discussed regarding this matter, both in Stoughton District Court and in this court, the Commonwealth has consistently maintained that their only justifications for requesting bail are, number one, the potential penalty my client faces, and number two, the nature and circumstances of the case. With regard to with regard to both, I'm concentrating my argument on changed circumstances. With regard to the potential penalty, in light of the changed circumstances that have and will be discussed during this argument, in light of what we've learned since the last time bail was modified, we believe, and my client well knows, the potential penalty she faces is nothing. There will be no penalty here because there will be no conviction. There will be no conviction because the evidence establishes her innocence. There is no jury anywhere who will ever vote to convict her for a crime she did not commit.
I think that this is the most interesting way to enter in a point using a motion such as this. This is a full-blown speech that gives a lot of information, kind of like a heads up to the public, I think, and to the courts. Like, do you really you might as well just go ahead and dismiss this case because even though this motion is about bail, I'm gonna give you some deets on the streets of Canton, Mass.
And that leaves us, Your Honor, with a bail argument that relies really exclusively on the nature and circumstances of the case. And the nature and circumstances of the case, as represented by the Commonwealth during its numerous bail arguments regarding this matter, have been shown to be false. It is a fact that the nature and circumstances of this case have completely changed, even since the last time this court modified her bail. The nature and circumstances of this case, in fact, are night and day from what was presented to Judge O'Malley in Stoughton District Court at my client's arraignment there over 19 months ago. At that arraignment, Your Honor, having read only the scant information that the Commonwealth made available to me, it was still immediately clear to me that this case was a tragedy but not a crime. From the very start, with most of the evidence hidden from the defense, the Commonwealth's case against Karen Reed was extremely thin. And from the start, she had no reason to flee, because even without the results of our investigation, her defense was strong. And it was strong because it was based on innocence. By the time I got back to my office that afternoon, I had already begun to learn that this wasn't just a tragedy, and it wasn't just that my client had committed no crime, but shockingly at the time, I learned that somebody else did, in fact, commit a very heinous crime. A friend and colleague of Brian Albert's called me on February 2nd, 2022, only hours after my client was arraigned, and named Brian Albert and his nephew Colin Albert as potential suspects.
Do you see why we go back in history? A lot of people out there are playing what everybody would expect me to play, the most recent amazing bombshells, which they are, don't get me wrong. But trial is starting tomorrow. We're going to see the bombshells throughout the 6 to 8 weeks, okay? Excuse me. So I'm not worried about that. On February 2nd, 2022, he got a tip-off. People forget this. Like, I even had somebody that was very well-versed in this case forget this little tippy tip. Let's go back.
Tragedy, and it wasn't just that my client had committed no crime, but shockingly at the time, I learned that somebody else did, in fact, commit a very heinous crime. A friend and colleague of Brian Albert's called me on February 2nd, 2022, only hours after my client was arraigned, and named Brian Albert and his nephew Colin Albert as potential suspects. That tip on day one of this case led us to do the investigation the Commonwealth did not do, the investigation they refused to do. And as my co-counsel has argued today, that investigation revealed that the Commonwealth's investigation was based on one lie after another. And the exposure of those lies is a major change circumstance which justifies lowering my client's bail to personal recognizance. I'd like the court to consider that at the outset of this case, State Trooper Michael Proctor submitted a report stating that Fairview Road in Canton had not been plowed during the early morning hours of January 29th, 2022. He claimed in that report that Michael Trotta at the DPW had told him during a phone call that he had with him after John O'Keefe was killed. We did not take Michael Proctor's word for that, and thank God we didn't, because we learned that was a lie. Rather than take Michael Proctor's word, we instead sent our investigator to speak to Mr. Trotta in February of 2022. He directed us to another man who led us to the plow driver who did plow the street.
Who did plow. And I'm pretty sure that other man was Aiden Kearney. But I know it is. We know it is. So is Turtle Boy important in this case to expose this crucial information? Abso-fucking-lutely. And we know that. We all know that. So you can't just dismiss this guy no matter how you hate how you hate his tactics. Like, you cannot dismiss the fact that he was a crucial part in this. Period. Hate the guy. Who cares? He did it. He did it. So it is what it is. So again, February 2nd, somebody comes to him and says, somebody told me. Somebody like a witness at what happened, the crime scene, the actual crime scene. And it was his daughter who was there. And her dad told him, this is what I was told. Okay, this is what I was told. And this is what started a bunch of stuff. This is where I think, honestly, this is the most crucial part on February 2nd. I think this is the most crucial part of the case. I don't think that anybody would ever get to where we are with Karen Reed's case without that. And bravo to her for speaking up. That one witness changed everything. And that's the bravest person in this case. The bravest. People forget that. People overlook that. And I have a hard time putting it out there because I believe she was a minor. So, anyway.
Our investigator interviewed plow driver Brian Laughlin within a couple of weeks of John O'Keefe's death. Mr. Laughlin told us what he has now told Michael Proctor, now that Proctor finally got around to speaking to him a year and a half after the fact. Shortly after John O'Keefe died, Brian Laughlin told us that he did plow the street in front of 34 Fairview, made a pass by there at 2:30 in the morning on January 29th, and when he passed that house, there was not a lot of snow that had fallen. Visibility was good. The lights were working on his plow. He passed right by the area where John O'Keefe's body would have been if Karen Reed had actually struck him with her vehicle. And he confirmed that at 2:30 a.m., plowing that area, there was no body there. And Mr. Laughlin was firm with Trooper Proctor. There was no body. And
there was no body. Nobody. At 2:30 in the morning. Okay, so where was John O'Keefe, guys? Where was John O'Keefe? Any ideas? Any suggestions? If he wasn't on the corner of the property, where was he?
Told him not only was there no body, but if there had been a body there, he would have seen it. He left Michael Proctor in the Commonwealth no wiggle room. The plow driver's testimony should end this case. To put it simply, no body at 2:30 a.m. means Karen Reed is innocent. Forget about all the other evidence that points to her innocence, but this one fact alone prevents the Commonwealth from ever convicting her. No body at 2:30 a.m., she is innocent. But, Your Honor, it's not just that he saw no body at 2:30 a.m. After that, he saw a Ford Edge parked right in the area where John O'Keefe's body was later found. Whoever moved that Ford Edge to that location in the early morning hours of January 29th, hours after Karen Reed left Fairview to go home, that person or persons knows exactly what happened to John O'Keefe. That mysterious driver and his or her accomplices likely know who beat up and killed John O'Keefe, and that person knows how John O'Keefe received all of the scratch marks and bite marks to his arm. This is all brand new information to you, Your Honor, as you did not have the benefit of any of this exculpatory evidence when you were deciding on an appropriate amount of bail.
I have to point this out. Brilliant move. David Yannetti is a genius because, you have to tie in your motion of bail with all of these bombshells, right? Like, get to the point. This is the bail motion. He just did. Because he is referencing the previous bail reduction motion. That was erroneous, in my opinion. Anyway, god dang. It's amazing to me.
Frankly, when the Commonwealth relies on the nature and circumstances of the case in order to justify bail being set, those nature and circumstances have changed in such a fundamental and drastic way that I'm surprised the Commonwealth is opposing this motion. When you set bail, you did so in part on a representation by Mr. Lally at my client's arraignment that there was that apparent hair on the rear passenger side quarter panel of my client's Lexus. We now know that Mr. Lally relied on the gross examination performed by a criminalist who failed her proficiency exam in performing gross examinations of evidence. We now know from the Commonwealth's own testing that not only did the hair not belong to John O'Keefe, it turns out it wasn't even a human hair. That is a significant change circumstance from what was represented to you by the Commonwealth, and that would justify.
I mean, reduce her bail because honestly, we shouldn't be here in the first place. I'm paraphrasing. Actually, I'm just acting out what I would have done with my ratchet self, right? We shouldn't be here in the first place because she ain't did it. It's obvious. Go ahead and save yourself from the embarrassment, Miss Canoni. Because you're about to fuck around and find out. Or fuck about and find around, whichever one you want. Right? And this is why it was very shocking for a motion to dismiss be denied. But they couldn't. They had to know who was under the gun. Who was the one? Even the people who support these alleged third party culprit murderers, they had to know. They had to know because they didn't want to be complicit in any way with helping and aiding and abetting, maybe? Is that the favorite word over there? Aiding and abetting?
By lowering her bail. When you last set bail, Your Honor, you had no idea that one of the Commonwealth's main witnesses, Jennifer McCabe, who had been at Brian Albert's house on the night in question and would have had to walk by John O'Keefe's body in the yard if it actually was there at that time, went home and at 2:27 a.m. Googled Hoslong to die in cold. You did not know when you set bail that Jennifer McCabe deleted that Google search. We have stressed to you ever since that our expert not only found that search, but we stand ready to prove beyond a doubt that Jennifer McCabe did it at 2:27 a.m. Our expert is certain. And importantly, the Commonwealth's handpicked expert, Ms. Hyde, confirms that the timestamp was 2:27 a.m., but says that the reason is unknown. This is all new information that you did not have when you have set bail in this case. And it goes without saying, Your Honor, that Jennifer McCabe's Google search, trying to determine just how much time had to pass before John O'Keefe would die in the cold, is completely consistent with her guilt or complicity in this crime and completely consistent with my client's innocence. You did not know this, Your Honor, at any time that you set bail, and this is a changed circumstance justifying a reduction. This is on top of the lies that have been uncovered. Not only did Proctor lie about the plowing of the street, not only did Mr. Lally represent that a human hair was found in my client's car when it wasn't, but importantly, Your Honor, you have been lied to by Brian Albert. In opposing our motion to get the animal control records, Mr. Albert's attorney told you that Mr. Albert's dog, Chloe, had no history of attacking human beings. Thank goodness you ordered the records, Your Honor, because we learned that was a lie. And to be clear, I do not believe for a second that Brian Albert's attorney, Greg Henning, would lie to this court. That leaves only one possibility. Brian Albert lied to him. Brian Albert told him that Chloe had never attacked a person. Brian Albert was desperate to keep these records secret from the defense and was willing to lie to keep them secret.
So the dog bite on the arm. I've already gone through the John O'Keefe arm injuries that are not consistent by a federal investigation is not consistent with Karen hitting John with her Lexus. But I think a dog named Chloe with a very aggressive owner named Brian Albert is way more probable. Bite marks, perhaps, or tug marks from teeth and paws and claws, right? That means that makes more sense to me. I don't know. But even though the Alberts say, no, Chloe the dog is not aggressive, that's not true. There were 2 incidences that they tried to keep from the defense of knowing of 2 prior incidences. So
the fact that those records have now been brought to court and revealed that Chloe attacked not just 1 but 2 people in the past, sending them both to the hospital, is a major change circumstance. Brian Albert lied, which is powerful evidence of his consciousness of guilt. You should have been able to consider that before you set bail in this case. But that
okay. So I'm going to jump off of this. There is more to it. But that's the big
information was kept from you. It is now.
That's the big things for me, right? Culpability. Everybody should have known at that point that third party culprit was like imminent. I didn't catch it because I'm not a lawyer. I'm not a legal professional in any sense of the word. But that should have really been the tip off. And I think it was the vibe anyway, right? But the defense doesn't really have to prove who it was that murdered John O'Keefe. It helps. And they have mentioned names. And that's what I want to know. Who really did it? Because you're not going to see, or the defense doesn't have to prove it, like I said. But John O'Keefe was still murdered. And I'm hoping that the federal investigation somehow proves who did. I'm almost positive they could. Or how many conspired to kill him, or whatever the case may be, whatever it is. But that's not Karen Reed's case. That's different. And I'm very interested to see who it really was. And I think that there might be an inkling into definitely 3 people are named in the defense: Colin Albert, Brian Higgins. Brian Higgins is the ATF agent who left at 1:30, 1:45 in the morning to go to Canton Police Department where he had an office. He's the one that destroyed his phones even after there was an order to preserve the phones. But somehow he prints off the text of only Karen's messages between him and Karen's messages and John O'Keefe's messages that he sent to John. Wow. But nobody else's. Just those. And then destroyed his phone. Brian Albert destroys his phone too. I mean, and I'm not trying to be rude to people that have an opinion that Karen Reed could be still complicit in some way, because it's true. She could still be in some way. But the charges on the second degree murder and the probable cause, when people say she could still be complicit, well, that's a whole nother level of evidence that you're saying your theory does not support on the probable cause and the evidentiary support or the evidentiary log. It doesn't support your theory. So like I keep trying to figure out a way to see myself around my confirmation bias. I definitely do. So if you could let me know what you think to help me with that, let me know. I have a hard time with that. And I hate being pigeonholed like that. So I do try to see others and their views, but I'm just not seeing it. Let me know if I'm wrong on that. So let me go to the latest and greatest. One moment. We're going to talk about Brian Higgins and what the lawyers say when they are requesting all of these phone records and stuff. The lawyers,
beyond the pale,
I think, is crucial testimony. And just their lawyers like Brian Albert and Brian Higgins and Jim McCabe's, because they say they are not a target of the federal investigation. Okay, one sec.
We've established that there is a close personal relationship between and among Michael Proctor and obviously Elizabeth Proctor and these third-party culprits that have been implicated in this case that we've brought to the court's attention, the Alberts and the McCabes. So he calls the evidence that we've procured and that we've presented to the court as lies. Well, let's look at those lies for a quick second. We have presented the court with photographic evidence, not something that we came up with, something they came up with. Photographs in Exhibit C in our moving papers. And I'll just cover a couple of those. There's a photograph that we presented that shows Trooper Proctor's mother, with a person by the name of Colin Albert, pictured in the photograph, with Trooper Proctor's sister pictured in the photograph, with Chris Albert pictured in the photograph, and with Jennifer McCabe's own daughter depicted in the photograph. They're all together at a birthday party. These are close and immediate family members of the Proctor family, the Albert family, and the McCabe family, and they're all together and they're socializing. That's not a lie, it's a photograph. And it's unassailable evidence of that relationship. There's a second photograph of Trooper Proctor and Colin Albert in a wedding party together. And I would urge the court to note, they're not at a wedding together. They're in a wedding together, in the wedding party. There's a third photograph.
When was that? When was that? When was that?
2012.
I wanted to point that little piece out real quick because Canoni pipes up. She knows these folks, okay? She's not, don't get it twisted. She knows these folks. And it's amazing to me that she kind of plays it off as, oh, when was that? 2012. Like things changed so immensely in that amount of time. They know each other. Their kids go to school together. These people went to school with each other before they had kids. You know what I'm saying? So it's very obvious. And I wonder if the judge regrets not recusing herself. I really do. Or maybe she's adamant that these people that she knows could never do anything such as cover up a murder of a police officer. I don't know.
Notwithstanding everything that's just been said and reserving the right to file that written document later on.
Come forward, and I don't know who counsel is for Mr. Higgins, but if he or she's here, do you want to be heard as well, sir? Great, so I'll hear you after I hear from Mr. Hennon.
So I skipped a bunch of stuff, but there's a motion from the defense to request phone records. And Brian Albert's attorney is here, and Brian Higgins' attorney is here. And Kevin Albert, which is the brother of Brian Albert, is also here.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian Albert, I just wanted to put three things on the record for the court. The first is, and I'm sure the court is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see that content. And that...
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did receive the court's order, and I informed each of the respective counsel that I spoke to as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron Protocol says shall, doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 17 in the case law protects, not be able to go forward without it?
And I understand there's a direct contradiction there. And so, out of an abundance of caution...
Okay, no, I understand.
Your Honor, what I think the counsel for the third parties would ask is that we are able to address the court today, but allow us an opportunity to review the memoranda and submit something in writing before the court makes an order.
Sure. I'm just rereading the appendix.
There are third parties in this matter and do not have access to the materials that are in the subject of the discussion from the federal side of things makes us at a disadvantage here in front of the court. Obviously, we're going to remedy that, hopefully, by being able to review it. But that notwithstanding, the fact that there is materials that we can't review that are being discussed in front of the court, even if we are able to see the memoranda, makes it difficult to address these. And I think for an issue of fairness, I want to make sure that the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point is, going into this, not having an opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be met regardless of whether we get to see the material or not. So what I do want to offer to the court to consider as part of your determination here is that after receiving the notice from the Commonwealth last week, I contacted the U.S. Attorney's Office and I spoke to the lead prosecutor in the case.
Okay.
What I want to have.
This is important. Okay. It just took me a long time to get there. He is about to explain Brian Albert's position in the investigation or lack thereof. Okay.
The court know is that I have permission to notify the court that Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the federal investigation. And I've been given permission to disclose that in open court.
Okay.
So Michael Proctor obviously is, right? It was named a month prior, I believe, or around this time. I think within the month before March 20th. I can't remember the exact date, but it was already out there. Okay. And Brian Albert is not the target. So, and his family. Okay. But who would be besides Proctor if it was already named? So are they just using that for good faith? Like, he's a good guy. He's going to comply, you know, trying to smooch the judge, basically.
I think
Maybe.
it's important for the court to know that as you go into the motion that you're considering and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Thank you very much.
Thank you. On behalf of Kevin Albert, present is Peter Pasciuco, and on behalf of Brian Higgins is William Conley.
Great. Thank you.
All right. Kevin Albert is the brother.
For me, please.
Yes, Your Honor. The last name is Colin.
And he, I believe, is like a 19-year veteran of the Canton Police Department. I think that's correct.
Connolly.
And what's your first name?
William.
Thank you. All right. I will hear you on behalf of Mr. Higgins.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and communications are at issue in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case, and he has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of seeing the factual support for these motions, but I want to provide some information that likely isn't contained within those materials submitted to the court, but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case.
So because, again, Brian Higgins is the alleged jealous potential dating partner in Brian Higgins' mind to Karen Reed, because Karen Reed and John were not having the best of times in their relationship. And Karen Reed, Brian Higgins had testified about a kiss, a little smooch, a little peck with Brian. So 2 weeks prior to this incident of John being murdered, they were watching I don't remember what game it was. Anyway, they were at John O'Keefe's house all together watching the game. And I guess Karen and Brian Higgins went in the garage to have a moment alone. But all it was a kiss. So it seems to me like Karen's downplaying the fact that maybe she wanted him to be jealous, John. Maybe there was some jealousy being planted there to get John to behave. We don't know. The fact of the matter is that there was some contention between Karen and Brian Higgins because they had been exchanging text messages prior to John's death. And Brian Higgins was at the Waterfall Bar, that night before being invited over to the house by Jen McCabe and Brian Higgins. Not to mention the fact that Brian Higgins texted Karen and went, excuse me, ma'am, in my country slang version. So obviously Brian Higgins wasn't too happy about it. So why is Brian Higgins inviting John O'Keefe back to the house? Potential third-party culprit motive, perhaps? Maybe.
represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has been confirmed.
So that sounds really nice and dainty and sweet, right? He is not a target of the federal investigation. Again, they already said who it was. So why is that not jiving? Because he took a proffer. Brian Higgins took a Fed proffer. What is a proffer? We're going to get into it and then wrap it up. The proffer thing is fucking crazy. Excuse my language, but it is. It's wild. So that's the reason why. Because when you take a proffer, you're going to learn here in just a second that it basically gives you, depending on the circumstances and how honest you are, and depending on the grand jury, it crosses, testimony, which he was caught lying in, and Brian Albert too. Sometimes you can get conditional immunity, or basically make a plea deal after the first or second session of these proffer meetings with the feds. Okay. Just depends on if you are actually telling the truth. You cannot be the actual person charged in a crime, a federal crime. Okay. So just think about that. But you could get information, give information to the feds to help their cause in exchange for, it's called the Queen of the Day deal. Basically, you get either you don't have to spend any time in jail for your knowledge or complicity, or it gets all taken away if you fuck it up and you lie, right? So you have to willingly go to the feds and give them this information in the form of a proffer. It's a very, very interesting thing. And I'll get someone to explain it better who actually has a law degree. But do not miss this because it's, wow. A lot of people don't know what it is. So, of course, he is not the target of the investigation because he is offering information to the feds in exchange for not being one, not being a target. Could he have been otherwise? Probably. Maybe. We don't know, allegedly. I don't know why else you would give a proffer. Unless you were complicit.
By the United States Attorney's Office and confirmed to me that I could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief request.
Good afternoon, Your Honor. Attorney Peter Paschuko on behalf of Kevin Albert.
All right, so you need to spell that last name.
Sure, it's there's been no showing how personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value.
Mr. Lally, you didn't want to add anything, did you?
Now, I'm going to skip Kevin Albert's attorney because honestly, I don't have any clue as to if, in fact, Kevin Albert is I don't know. I don't know anything about his involvement in anything, honest to God. So I'm sure that if it was relevant, then it'll come out in trial. And I don't want to confuse myself or you guys. That's for sure. But here we go, y'all. This is the boom diggity bomb. And this is where I will wrap it up after this in the proffer. This is where everything is going to kind of come to light, in my opinion, as to the juicy baseline proof and very believable proof, in my opinion. Defense, third party culprit defense. I'm buying it. That's for sure.
Mr. Lally, you didn't want to add anything, did you?
No, thank you, Your Honor.
Okay. All right, so this motion concerns Brian Albert, Kenneth Berkowitz, Brian Higgins.
Yes, and Your Honor, with the court's permission, I'd like to start with Brian Higgins with regard to this motion.
All right, so Mr. Lally, is it safe to assume you did not provide, or you didn't comply with my order in providing the motions and supporting affidavits on this as well to the third party record holders and their lawyers?
Yes, Your Honor.
Okay. So the counsel will receive copies of this as well and be permitted to argue now and supplement it. All right.
Thank you, Your Honor. As I previously mentioned, Brian Higgins did testify before the federal grand jury. And at that time, he was specifically asked if on January 29th of 2022, he made any phone calls when he got home. He said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29.
2:22. Dang. 2:22 that morning, he gets a call from Brian Higgins. Brian Albert, the homeowner. Is that what I'm hearing correctly? After the federal prosecutor requested these records. So the federal prosecutor already has it, which would be in their investigative report, which the Commonwealth and the defense have over 3,000 pages, I believe.
Brian Higgins at 2:22 in the morning on January 29. Those records were...
Why? He was at the Canton Police Department at 1:30-ish or thereafter. Why is he calling Brian? Brian's in bed, chilling, trying to get his game on with the missus, as we will hear here shortly from the butt dial debacle. But I don't know. It's kind of sketchier that you're calling at 2:22 and nobody knows where John O'Keefe is.
Reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's witnesses to explain the many calls between them and among them, and I've never seen a case where there have been so many butt dials, to be frank. But Mr. Higgins was already locked in. He already testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records would have reflected a voicemail if they went to voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Alberts to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds.
Remember, Brian Higgins goes and destroys his phone after he was told by a witness advocate that was not supposed to happen at all, based on the motion to preserve the phone. They did. Brian Higgins and Brian Albert did not want those communications being brought to light. Why?
Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise, it is clear this is no longer a fishing expedition. We do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning, again, about 3.5 hours before John O'Keefe's body was found.
All right, so allegedly John goes into the house roughly 12. When did she arrive? 12, 18 to 21. Damn it, I got to pull up it's late and I got to pull up the sheet. I got to pull it up. I always get the time wrong on that. Thank you, Soothie Goosey, for saving my ass on this right now. A lot of cases have a lot of timelines or lack thereof, so give me a break. Thank you. So, communication log. I feel like this is missing a lot. Maybe she reformatted it. So, I think 12:18, it was the text where to or a call. One sec. One moment. So 12:11, Keith's phone. There's a reason why I'm looking at this one too, because it kind of shows how many steps were taken. I'm just refreshing my memory. So she pulls out probably about like 12:30, 12:31, something like that, and arrives at 12:41. So I would assume she said 15 minutes. So like, let's just say 12:20-ish. Okay, 12:18 to 12:20. He's heading into the house. I'm pretty sure that's what everybody came to the conclusion on. It doesn't matter. At the end of the day, from 12, let's just say 20, all the way to 2:22, when Brian Alberts and Brian Higgins call each other and butt dial or whatever. What the hell happened? What happened? And who was skedaddling pretty quickly? And where did they go, right? Those are going to be very important, crucial things. But I think personally that it happened very quickly. Whoever it was, maybe Brian, maybe Colin, I don't know. I think it happened very abruptly and quickly. And I don't think that John died immediately. I think they thought he did. And they obviously could not just take him to the hospital. In my opinion, this is just my theory. This is kind of my theory leaking out. And that's okay. I have a right to a theory. Doesn't mean I'm right. It's alleged. Everyone is innocent until proven guilty. But I think that whatever happened and whoever did something to John, I think that they were waiting for him and coming up with a plan as he was dying. And it took longer than they thought. I really do. And they were coming up with a game plan, whoever they are, right? Because you really don't see much or hear much about communications and what was said in between those two crucial times of, 12:30 onward. You see the Google search. I think what I'm trying to say is that there's going to be so much more bombshells on what was said to whom that we have no idea about.
Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time. The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed. So now he's claiming that it was during that intimate situation with his wife that he supposedly butt-dialed Brian Higgins. He had no explanation, however, for how his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed. And it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt dialed Higgins. But again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29, 2022 calls between Higgins and Albert. Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found.
Right, which is the same Chief Berkowitz who magically found the biggest taillight piece randomly driving down the road by the Brian Albert home. Voila, it's there. It's just sitting there because the snow melted and there's this big piece. Let's call it in. Right? Which he soon retires after that. Brian Albert makes a very nice donation to his retirement party.
And again, recall, they're supposedly conflicted out of this case.
So I'm going to, there's just a question I have, and I'll let you continue, Mr. Yannetti, but regarding the dates. So that the dates of the records you're seeking for Brian Albert, so January 29th to February 4th.
4th or 5th, yes.
4th.
For Albert, we had evidence through the 5th.
All right, it's not entirely clear from the affidavit.
By the way, I'm reminded when I sat down that District Attorney Morrissey announced that publicly. So we knew that early on.
Okay, so is that
Berkowitz for 4 minutes. Multiple times without finding it. But somehow, Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle. And the phone records, we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist, but they haven't released the actual records. Contact between co-conspirators could not be more. Called Higgins that very day to tell him about the discovery. Found a piece of taillight on Brian Albert's lawn on February 4th. After that lawn had been searched by trained investigators and other police officers multiple times without finding it. But somehow, Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle. And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging, as part of our defense, that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits, contact between co-conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful. Although we never had to prove that the phone records actually contained evidence of the conspiracy. That's something we couldn't do without having the records themselves. This court has previously ruled that it was all too speculative.
So the third-party culprit defense cannot be too speculative and based in theory. There had to be factual-based reasoning and logic without too much speculation, right? But it didn't have to mention who it was. So the judge was nice enough to say, that is not, what you're giving me is not enough. I need more. And I think that was, it's smart. It's not wrong, in my opinion. But also, what else do you know? Right? Even though she has 3,000, the 3,000 pages and the grand jury minutes that are impounded. So I don't know.
Not anymore. Not now. Not after we know that the records exist. Not after we know they prove what we suspected that they would prove. We now know that those records will tell a story that could not be more relevant to this case and to our defense. And the problem, Your Honor, is we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist, but they haven't released the actual records to us. They have them. We don't have them. That's why we're...
So this again, but this was in March 20th, 2024, this hearing. They get all the good stuff later on, right? 3,000 plus pages. So that's kind of the issue, is that they're having to introduce this evidence as they're reading and going along. And that's why he is stating, we need it in admissible form once we get it, so hold off on your ruling. Don't shut us down yet. And of course, why would she? Because she wants to know. Once that motion is denied, do you think that they're going to just say, hey, but you could have this federal investigation information? No, it is irrelevant now, but she needs to know. She's got to know. And she does eventually when they give it to her, when the defense receives it.
Filing this Rule 17 motion. And again, we've more than met the requirements of Lampron. These records are relevant to our defense because they show suspicious contact between parties we allege to be in a conspiracy. They're relevant because they show the Canton police chief inserting himself into a case when it was previously determined that he was conflicted out. They are relevant because they impeach the credibility of Commonwealth witnesses who denied talking to each other, yet have no explanation for these records, which again,
Brian, Albert,
not lie.
and Higgins.
We cannot get the records any other way. We cannot effectively prepare for trial without these records. The Commonwealth could have gotten them, but they chose not to. They fought our efforts to get them. But again, thank God, another law enforcement agency stepped in and did what the DA should have done. Going to trial without these records would violate my client's due process rights. And finally, to the extent that this court previously ruled that our requests were a fishing expedition, we can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition.
Oh, that's got to be a soundbite. We have the receipts.
Going to trial without these records would violate my client's due process rights. And finally, to the extent that this court previously ruled that our requests were a fishing expedition, we can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition. We were merely on an expedition to obtain relevant material and exculpatory evidence, and we're simply on a mission to defend our client. And I would ask the court to allow this motion.
All right. Thank you very much. Mr. Lally? That's why I asked. So
my question was a different one as to the dates, though. So when it directed.
Yes, thank you, Your Honor. Your Honor, well, with respect to our general arguments, we'll just rest on what I said previously, and we respect the parties' positions. I just want to point out one thing with respect to the factual assertion. I don't have the privilege of seeing the grand jury testimony, but I can represent to the court that before my client ever testified at the grand jury, he voluntarily appeared for an interview with the U.S. Attorney's Office. I attended that interview, and at that interview, he volunteered to the U.S. Attorney's Office that on that morning he spoke to both Albert and Berkowitz,
AKA proffer. There was a proffer. So that's where the proffer comes in. All right.
He was not asked and did
Brian
not give a
Higgins.
rundown of how many times, but he acknowledged long before he testified at the grand jury that he did speak with both of them that day. I don't think that impacts the substance of the arguments, but I just wanted to note that.
Okay, so just so I'm clear, the Commonwealth hasn't objected to these records for that period of time that appears to be relevant time period.
And so I will waive argument on that, Your Honor.
All right. And does counsel object to these records? Mr. Henning on behalf of Brian Albert? All right. And counsel on behalf of... Oh, that doesn't concern you. Okay. All right. Thank you. Malaya?
Okay, so trying to make this as fast as possible. I'm just gonna find something to summarize it because we are way over time. Poor Mr. Eve. Thank you for being here. Even though I don't have a lot of viewers, it doesn't matter. This case matters so much to every single one of us when it comes to misconduct. It's crucial, no matter who you are. This could happen to anybody, you, your loved ones. You know what I mean? You could be set up. And this is pretty much a textbook, in my opinion, not a textbook example, but it dives into how they did it. In my opinion, this federal investigation, once it's complete, is going to show you exactly what you need to look for, what you need to notice, what you need to be involved in to prevent it. There's so many things that everybody can learn from this case and the federal investigation, the internal affairs investigation, to protect yourselves, because authorities and bodies of government get too big for their britches, and this is exactly going to prove that the information from, in my opinion, the information from the documents that are going to be released one day. I just cannot believe that it is coming through a murder trial of a Boston police officer, and they're framing his girlfriend, his long-term girlfriend. You really have to sit and think with that. Sit with that for a minute and ask yourself if that was you, if this happened to you or your daughter or your brother or your sister, what do you think you would do?
All right, Brian, we have a 3 o'clock list. Okay, thank you.
And don't think it won't happen, or it could never happen. Why do they not want to talk about the proffer? Let me see if there's just something I can read. I had the link, but my Discord crashed. Oh. A federal proffer. Brian Higgins is the one who participated in the, yeah. Okay. I got a leak from here. One sec. By the way, Brian Higgins, ATF agent, he is very familiar with the federal proffer process. He would be involved in that process with people that he arrested, people that he interviewed for whatever crime he was involved in investigating. So he was very, very knowledgeable in how it all worked. He knew exactly what to do. And it would make a lot of sense if, knowing how it works, knowing in your mind that you could maybe use that to your advantage by maybe letting somebody else do the dirty work of harming John O'Keefe. I don't know. Or maybe they didn't anticipate killing John, and it eventually, whatever happened, that's what ended up happening. I don't know. But the long run of it, in my opinion, his thought processes, Brian Higgins specifically, was to cover his ass no matter what, right? And using his knowledge of his job as an advantage. That third party culprit is strong, way more, in my opinion, receivable by a jury and convincing with no doubt of what had happened, especially if they have more text or communication evidence, because obviously the video footage is just gone. How about that? Very interesting. Right? That's just my opinion. So this dude right here is a federal criminal defense attorney, and I promise we're going to get off here. My ears. All right. So he's going to explain the proffer, and I swear I will end the live. 12 minutes tops. But this is kind of the process. And he explains exactly what happens and the reasoning for the proffer. Okay.
It's a offer for our clients to provide information and cooperate with the government, usually in exchange for some sort of benefit at sentencing and potentially no charges whatsoever. And that also depends a lot on where they are on that spectrum. Sometimes it's the only way to really gather the information that you need. It can be used as an investigatory tool by the defense, but you have to be very careful doing it that way because the government is not as smart as they seem, but they are smart. You might also hear this proffer referred to as a queen for the day agreement. Sometimes it's also called a debrief. And the best time to do it is early if you're going to do it, and we'll talk about why, but it could come at various stages, even once a prosecution has already started. So usually the U.S. Attorney's Office or Department of Justice Criminal Trial Division is investigating someone, and if they either think that your client has information that would be valuable for them to know, or if you learn that your client, from building that trust with your client, that they have valuable information, you want to set up a proffer session. Maybe other lawyers are different about this. I try and set up at least an initial meeting, proffer session, in every single case I have. Even if it's very clear that the client, the case is just about them. If they forged a passport, maybe, and you think, well, what do they have to know? You never know. You never know. Questions, sometimes for the entire first session. Really, these are the kind of tricks of the trade that I think a CLE like this is so important about. The first meeting, or at least the beginning of the first meeting, is a truth serum. It's an audition to see if the government would even want to potentially use your client as a cooperator.
Okay. All right. So there's sessions to this proffer. You basically fill out the information of the proffer to be looked at by the federal government. And then they basically see how you do. Do they even is this person even worth looking into and taking their information as gold? Because he's going to tell you here in a second that 9 times out of 10, basically, the government already knows the story. They're just going to see how your story matches or doesn't match.
Against a co-defendant, providing information that leads to other arrests and investigations in general. And so what they do when they start off, and again, my primary practice is in the Southern District of Florida, but I've had cases around the country, and pretty much standard across the board is they will ask questions, sometimes for the entire first session, which seems like a waste of time, but they have their reasons that they already know the answer to. So when you're preparing your client for a proffer session, you're deciding whether or not we should go in and cooperate. There's a lot of things to take into account. Most effective thing that I do, and that other lawyers who are my mentors and great federal defense attorneys will say, and that you should always tell your client before a proffer session is, if you go into the session and you want to provide information, and it's voluntary, they're not compelled, it's not under a subpoena, it's voluntary to try and help yourself by helping the government, is to assume that every single question that is asked of you, every single question that the government asks your client, tell your client to assume, presume, and just on the word of God, the government already has the answer to the question. Because if you can get that concept across to your client and they believe in it and they trust you and they can follow that, then there is no possibility that they will lie to the government. That there's no possibility they will omit or exaggerate or minimize. You just
that's
answer
common
the question
knowledge.
that was asked.
Just don't lie.
Nothing more, nothing less, just what was asked, and just assume they already know the answer, because they usually do. And even if they don't, if you assume that they do, then you won't lie. And we're going to talk about why it's so important that you don't lie, other than obviously it's not good to lie to a federal agent, because there's specific consequences if you decide to proffer. Usually the first time, if you pass the audition and then you want a goal is to have a second to third proffer, maybe if your strategy in a case is for your client to cooperate for their benefit, the attorney does play a large role in the proffer as well. Most of it is us sitting and listening, but a very important part is a very high intensity situation. I mean, your client is there, they're volunteers to honor that. If the client says, I train them and we prosecutors and the agents, I've had ones where there's been 30 people in the room. Every single one of them will gladly get out and they will leave the room. So you can ask a question. Tell me everything you know about the year 2021 in check 2, and don't be afraid to do so. Or the agents, if they're the ones that are asking the questions. Preparation for these is everything. One of the hardest parts about a proffer when you're deciding whether to proffer or not is the client, at the start of any proffer session, even if it doesn't happen in the very beginning, it happens 10 minutes in, 20 minutes in, is whenever it is, your client has to accept responsibility in that proffer, or the government will not use him. They'll say,
did you hear that? Let me back it up. Think of Brian Higgins, who we know has used this proffer.
Your client has to accept responsibility in that proffer, or the government will
Thank
not.
you, Mr. Eve. I'm trying.
They'll say they won't use whatever he might have already said, he or she, to that point against him, but they'll say, thank you, we're done here. So I've seen a lot of pitfalls. I had a client come to me where his lawyer didn't prepare him. They went to the proffer in a very big healthcare case, and my client thought that this was his opportunity to defend himself, to explain why the government was wrong. Apparently I wasn't there, but my client said it got very hostile. And from the very, very beginning, he lost trust. The defense lost trust with the prosecutors. It's hard to recover that. It takes a lot of experience and knowing how to recover it, but it can be done. But you want to start off the right way. So a proffer is not a chance for the client to come in and say, I'm innocent. It's not what it's for. It's to accept responsibility, be truthful, and then gain a benefit from doing it. And we'll talk about those benefits. But before we do, probably thinking, well, if he comes in, a client comes in with you and he accepts responsibility, these usually happen in a perfect scenario, they happen before he's been charged. So isn't he just voluntarily confessing? David, I thought you said he should not give up his right to remain silent. That would be really bad. So in a proffer, okay, and this is another huge role of the defense attorney, and one of the most important parts of a case, if you can can persuade the prosecutor to give your client the opportunity to help themselves by cooperating, they provide something called a castigar letter, or a queen for the day agreement, they call it, or very often a proffer letter. And you'll want to read the case of Castigar. It's a great case. And it basically, what that does is it provides a form of conditional immunity. And there's different kinds of immunity.
Ooh, so immunity of some sort is the goal here, obviously. But the big question is, what's the charge and who's getting it? Who and what and why? Because if the investigation is directly due to the Karen Reed's investigation, right? And it also includes the trial per Boston 25. It's not just the investigation, it's also the conviction or the outcome of the trial. So it extends further in not just from the start, but what's happening now. I think there's a lot more power that maybe the Commonwealth is underestimating. Maybe they know exactly what's going on and they're just playing it. They're just playing it out like we really have that much authority to change or sway the federal government, right? That's just my opinion. I don't know that for a fact, but that's just how I would see it. Or that's how I see it. But it's very interesting. Who is being charged? Who is the target again?
For the most part, I could talk about proffers for 5 hours, and we have other topics to get to because they're so interesting and they're so important.
And what I meant to clarify is, who's the target? Michael Proctor, right? So just because he's a target doesn't mean that he's going to get charged for the specifics of John O'Keefe's undetermined death, right? Of course not. He wasn't there. I'm sure he wasn't. But the investigation itself, where he's a target, there might be more to it, to the end game of maybe revealing who did, right? I think everybody can kind of catch on to that. I'm very curious if it reveals itself so far in those documents.
But really what use immunity is and what this conditional immunity is if you're being truthful, if you're not omitting, if you're not lying, and if you're not embellishing or exaggerating or minimizing your role, if you're following the requirements that your attorney has explained to you, and the prosecutor always says at the beginning too what is required of them. And we've already gone through, and I'm going to show you an example of the letter, but it lays it all out right there in the letter. If the requirements have been followed, then whatever your client says, okay, during that session cannot be used against your client at any stage. Okay, and that's really important. Really.
But that's only if you tell the truth. So if you're honest and that's what happened and that's it cannot be disputed. It cannot be used against you. But remember, Brian Higgins and Brian Albert didn't speak to each other, right? They had to go to the second grand jury to clear that up, right? So does that infer lying on a federal grand jury hearing? And what does that mean regarding proffers? Ooh, I could be wrong. I'm not a professional. Just a thought. Maybe I misunderstood something.
Really important. There's a caveat to that. It's with an asterisk. And there's a few things that can change that. One is if your client lies. Okay, if your client lies, whatever he's told, he or she has told the government during that session, it can be used against them. That's why you have to, developing the trust is so important there. Because before I go into a proffer session, I have to know everything my client is going to say. Because if I don't know he's lying or she is lying or omitting, if I have a good prosecutor and have a good relationship regularly during a session, ask to take a break and we'll ask the prosecutor today so far. For the most part, at least in the Southern District of Florida, they will stop it. They're not malicious, and it can become a big issue later if they know your client is lying and then they elicit more testimony from him, knowing later that they're just going to say, oh, he lied, so now I'm going to use it against him. They're better than that for the most part.
Ooh, that is that right there. So if he lied or falsely misrepresented the relationship between Brian and Brian and their communications, ooh, what does that mean? Is Brian okay? Is he out there? Where he be? Where is he? Is he on vacation? Is he still working? I just wonder.
But again, that's always been my experience. I have had cases where federal prosecutors can really take some liberty, so you have to really be on your toes. And if you don't think that your client can follow those terms, or he isn't ready to, or he's very hesitant, then don't do it. It's not worth it. Other ways that your client's statements he could lose that immunity, that use immunity. And we said use immunity because it's them using statements against his own statements against him, to either build charges against him, new charges, or to make sentencing worse, to use against my client at trial. They can't use any of those. That's use immunity as long as he's following the terms, and we're following the terms of the letter of the proffer agreement. Now, if your client also does decide to testify, because you can proffer and you can still go to trial. You can still say, we're fighting this. Thank you. We've told you what we know. But your client can't testify if you've proffered. If your client testifies at a trial, and technically the client could testify, but if they've proffered, we've only gotten through a proffer because they have essentially confessed. So you just
confess to what? What would he confess to?
Really wouldn't put a client on the stand at trial, because if they were consistent with their proffer, then obviously they would be saying, I accept responsibility, I did something wrong. So they can't testify. And if they did decide to testify after a proffer, they could be hit with an additional charge of obstruction of justice, which is no good.
So what I'm trying to get at is Brian Higgins is not a target. So it would make me think that, not that alludes to him being complicit in John's alleged murder, but I wonder if he was testifying and the two Bryans were testifying. Did Colin Albert testify? If anybody could confirm that Colin Albert himself testified in any way, shape, or form of this particular federal investigation, I think that it might show if he may be involved in John's. This is alleged. Please know this. Is he involved in the actual alleged murder of John O'Keefe? Is Colin, in fact, potentially the one that so many people would be willing to die by the sword and go down with the ship and protect at all costs? Does it kind of make more sense to you? It does to me. So if I were to have a theory or a opinion on my theory of the third party culprit defense, and I'm allowed to have that, I don't give a shit. You can't take that away from me. I'm just a person on YouTube. But if I were to proffer who may have done it, who did it, main culprit, it would be Colin Albert, 100%. And I hate to say that because he's a young man. And I don't know the details. Maybe it was Brian Higgins' jealous rage. I don't know, but I'm not really convinced on that right now. Because it just seems to me that they did not want Colin Albert in the house in any way, shape, or form, but he was in there. That's just my opinion. That's just my opinion. I would not see a cover-up being worth a damn, even if you were besties with all of these people, unless it involved a young man with a future at stake. That's just me. I'm going to finish this and we're going to go.
Something else, one other area is called derivative use immunity. Derivative use immunity, and these are really the three ways that you get immunity or don't. But derivative use immunity basically means that if your client gives information during the proffer session that's protected, and that information leads them to a source, okay, to another individual, and they speak with that individual, and that individual provides his or her own information about your client, we don't get to go back and say, well, you can't use that because my client told you that too. If the government can establish that they learned it from an independent source, It's it's complex. I could talk about it more. There's a lot of case law on derivative use immunity. It's highly litigated, but just know that the immunity is conditional, and you really, before agreeing to a proffer, you want to do your research or talk to an experienced attorney about the types of immunity that can be conferred. So I'm going to show you an example of a recent proffer letter. So this is a very good example of a proffer agreement. Each district does them differently.
Yeah, so this is probably just an average proffer agreement from what I've looked at myself throughout whatever district it is. But basically, it just gives you the proffer agreement, and it varies depending on the case and the person and the information. I have no idea what Brian did, right? We aren't going to know that agreement in its entirety yet, or maybe never. I don't know. But let's scroll down a little bit. Those are the basics. You're going to be honest, right? You accept the proffer, right? And then here's the detailed agreements. Confer immunity upon the witness for any possible federal criminal acts committed by the witness. What would Brian Higgins' criminal acts be? Not reporting the murder of a man? Maybe. I don't know. Maybe continuing to lie habitually and break orders, like preservation of your phone, perhaps.
Right.
I don't know.
But again,
I
it
don't know.
depends on where your client falls too. If it's a witness or a suspect, maybe you can get it if you've done great proffer. In this case, actually, it was a target. They called it a witness, but it does depend, again, why that spectrum is so important. So paragraph 2, they say, we're not making you any promises. Paragraph 3, I love this.
No problem. Takesy backsies are a thing. So just know that.
Language, it's not as good as a language as we usually get, but this is what I propose. Unless specified otherwise, no statement made by the witness during this will be offered against the witness in the government's case in criminal chief in any criminal prosecution of the witness or an aggravation of the witness's sentencing for the matters currently under investigation in accordance with sentencing guideline 1B1.8, except in a prosecution for false statements, obstruction.
Oops. So this is what I think is going to get somebody, right? Witness in the government's case in chief in any criminal prosecution of the witness or in aggravation at the witness's sentencing for the matters currently under investigation. So what does that mean for Karen Reed's case, though? Because it's two different things. I don't think it matters. That's why it's being entered into evidence. The investigation, the federal investigation information. It's discovery. And of course, the judge has discretion on that. But Brian Higgins is a witness. Michael Proctor is a witness. So
of justice, or if they've lied during the proffer or otherwise omitted or minimized or violated the terms of the letter. So practice tip, any proffer letter that you have to make sure that it mentions sentencing guideline section 1B1.8. This is the guideline that talks about what the government prior to a sentencing will provide to the probation office. I don't want a letter. It's not in every letter, but it does basically, or it could be very damning against yourself, but you're doing it to help yourself so that the judge doesn't know at sentencing. So 1B1.8 is really important to have in here. Paragraph 4 is about derivative immunity. We talked about obtaining leads. If your client testifies, we talked about at trial or otherwise, then what has been said in the proffer can be used for impeachment. They can be cross-examined with it. If they're
and they're going to do that. Elizabeth Little said that they plan to cross-examine Michael Proctor if he goes on stand, which is the target of the investigation, which is going to lead into people that are involved in the federal investigation. I'm almost certain that is going to happen. It's been pretty much said by Yannetti. So that's what that is what's going to, in my opinion, expose things. If the charge doesn't come out of the Fed, is going to come out of the testimony of the Karen Reed case. Wild stuff. I don't know if I'm 100% accurate on that, but I just assume that charges are going to come from either one, right? Because they're being examined, cross-examined. The witnesses, which is Michael Proctor. Insane. It's just mind-boggling, this case. I'm on the edge of my seat. I just hate that Karen Reed even had to go to trial, but I think it was necessary. It was absolutely necessary to maybe get a charge on who actually murdered John O'Keefe. Maybe it was destined to go to trial for that reason. Or to continue to cover for each other. I don't know. Who knows? We'll see. Thank you guys for being here for almost 3 hours. You were lovely. All my 10 to 14 viewers. I don't care. It could be 0. I'm fascinated with this case, and I hope that some of this stuff will pop up into your minds when you watch the trial with me. All 10 of you. Doesn't matter to me. I'm going to be here. All right, I'll see you tomorrow then, because trial starts. Much love to you guys. Bye. Have a great night.
Gone somewhere and dyed my hair now. Wanna be alone. It's much to bear and you don't care, and I wanna play alone. I got you